judge in civil cases, but I'm here. I get a lot of, I sort of cover the water. And I do some questions. If it looks like the case is going to be expensive, but it's not decided. Judge on this, like
All rise. Florida's District Court of Appeal, First District is now in session. All those with cause to plead, draw nigh, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Well, good morning. This morning we have one oral argument. It's for two cases that we've consolidated for oral argument. One is Michael Acosta versus the Department of Children and Families, and the other is Joseph Acosta versus the Department of Children and Families. Each side will have a total of 15 minutes to present argument. And with that, if the appellants are ready, please proceed.
Good morning, Your Honors. May it please the Court, my name is Seida Wood. On behalf of the appellants Joseph Acosta and Michael Acosta, I'm here with Bernard Perlmutter and Brian Stewart from the Children and Youth Law Clinic at the University of Miami. I'd like to reserve 3 minutes for rebuttal. These appeals stem from the Department's termination of the appellant's RTI stipend. Because this is a Department's termination, the burden of proof is on the Department to prove by preponderance of the evidence that the boys were ineligible for RTI. At issue today is whether the boys were Florida residents for purposes of RTI eligibility.
As I understand the facts, in 2006, both boys went to live with their aunt as a result of the death of their father, and that the mother was, natural mother was determined not to be capable of caring for the children under the interstate compact. But at a certain point, both those boys, Michael and Joseph, turned 18 and elected, it seems to me from the record, to characterize New Jersey as their home based upon certain indicia or evidence of intent. A driver's license, voter registration for the older boy, registration of a motor vehicle for the younger boy, attendance at school, and other things. Why would those variables not be outcome determinative?
Well, in this, and you're correct, Your Honor, that intent is vital to be shown in order to show change of legal residence. So there's no question that the boys were originally Florida residents, and Florida retained jurisdiction until they were 18. So the question is whether at some point after they turned 18, the boys affirmatively changed their legal residence from Florida to New Jersey. And in order to show that, Florida case law has been clear for over 100 years that you need removal, which we have here, and a manifestation of an intent to permanently establish a new residence. Now, in Joseph's case, Joseph testified at the hearing, and this was the only evidence at the hearing.
He testified that he characterized New Jersey as his home. Is that not correct?
Michael testified that he characterized New Jersey as his home. Joseph testified that he had intended to pursue his education, complete his education in New Jersey, and at that point move down south.
But he had registered to vote in New Jersey.
Correct, Your Honor. He had registered to vote in New Jersey. He had aged out in New Jersey. So, and these boys didn't choose to move to New Jersey.
But he chose to register to vote in New Jersey.
Correct. They did. They chose to register to vote in New Jersey. And they chose
Joseph did. I don't know about Michael.
And they chose to get New Jersey driver's license.
Right.
But in this case, where you have boys that were removed by Florida and placed in a Florida foster home in New Jersey, and they haven't left that placement. They haven't left the Florida foster placement where they were. This wasn't a permanent placement. A permanent placement would have been an adoption. This was a temporary placement. And Joseph has maintained a consistent intent that he manifested initially in his RTI application, where he said that he wanted to remain in New Jersey until he could move back to Florida. That was in January of 2010. A year later at the hearing, he testified to the same intent, saying Florida was his home, Florida is the only place he ever knew, he has sisters in Florida, and he intends to move back to Florida after he completes his education. This is in keeping with the purposes of the RTI statute,
He had
which
in-state
promotes.
tuition at Monmouth University. Is that not correct?
Michael is in Monmouth University. So for Joseph, in Joseph's case, he's in high school. At the time of the record, he was still in high school. He manifested a clear intent to remain in New Jersey for purposes of completing his education. Now,
Well, tell us what, from your perspective, what do you think this particular RTI grant is for, and why do you think there is a residency requirement for it?
This grant is for students, for former foster youth who've aged out of the foster care system in Florida, to provide them with an opportunity to complete their education. In many cases, they wouldn't be able to complete their education because of having financial burdens. In many cases, they have children that they have to support. So the RTI funds are need-based and take into consideration things like electric bill, water bill, housing, transportation costs, and the full amount of the funds would be akin to what a foster child would make working in a 40-hour work week. So the purposes of the statute are to promote this independence, road to independence, especially through the means of getting an education.
Well, why do you think there is a residency requirement? Because obviously under normal, I wouldn't say normal, but probably in general, a foster child would age out of the system. He or she would have been placed with a foster family here in Florida, and then if interested in pursuing the RTI grant, would apply for it, would be going to school here, would be living here in the state.
Correct.
Your clients seem to be in a different posture, particularly when they've expressed a desire to go to school in New Jersey, they have driver's licenses there, they have registered to vote there.
Well, I think it's important to note that the intent to establish a residence for purposes of education under Florida law is considered only a temporary residence, and that's under the Florida Administrative Code chapter on student financial assistance defines residency as, and let me just pull it up and read this. So these are the definitions of terms for state student aid programs. This defines residency as the legal status which a person acquires as a result of establishment of a domicile with the intent to permanently remain in that domicile other than for temporary absences. However, any domicile established solely or primarily for the purposes of obtaining an education or of obtaining financial aid from the state shall not constitute residency. So in this case where we have Joseph's year-long consistent intent to remain in New Jersey to complete his education and his testimony about how the stability of his placement in New Jersey has actually furthered his ability to maintain and complete his education. And so at that point, the intent, the only expression of intent, explicit expression of intent, is to establish a temporary residence.
Did either or both of these young men receive in-state tuition assistance from the state of New Jersey?
Michael did receive a tuition aid grant of $800.
And that was based on residency?
That was based on residency, but, Your Honor, we don't know what the New Jersey residency requirements are. We don't know if they equate legal residence
I saw
to a place of
you
abode.
argued that in your brief, and I picked up on that point. But it is nonetheless, whatever the requirement is for qualifying for in-state tuition in New Jersey, we don't know.
We don't know.
From the record what that is. Nonetheless, is it not some sort of indicia of intent on the part of Michael that he applied for and was granted in-state tuition? Does that not go to his state of mind?
Well, that was one piece of evidence, and the hearing officer weighed that evidence as well as Michael's testimony in the hearing that he stayed in New Jersey in large part to complete his education, and if it wasn't for the stability of his placement in New Jersey, he may not have been able to complete his education. He was several years behind. So the hearing officer weighed all that evidence and found, as a finding of fact, in her factual findings, that Michael chose to remain in New Jersey to complete his education. So in
it seems to me that, I mean, what you're hitting on now is precisely my concern, and that is the issue of legal residency is largely a factual determination to be made by the hearing officer in this case. And it seems to me if there is any CSE, or unless there is no CSE to support that, we're required to defer to that factual weighing done by the hearing officer.
Well, and the hearing officer did find, as a finding of fact, that he chose to remain in New Jersey to complete his education. Under Florida law, that intent is not sufficient to establish a permanent residence. And that's explicit in the Florida Administrative Code that deals with residency and deals with the statutes that deal with state aid and state financial aid. So in Joseph's case, there was not even a finding of intent. But there was very clear, year-long manifestation of a consistent intent to, look, I'm stable here, I'm going to stay in New Jersey here to complete my education, then move back down south. Florida's my home. And in Michael's case...
Well, he said back down south. He didn't say back to Florida, as I read the record.
Originally, in his transitional memo, he said back down south. In the hearing, he did clarify that he meant Florida, that he has family in Florida, that he wants to move back to Florida. But in order to show that there has been a loss of residence, because the Florida residence has been established, and they've been Florida residents at least until they were 18. So in order to show that there's been a loss, it's necessary to show by preponderance of the evidence that they had an intent to permanently establish themselves in New Jersey. In different situations, for example, a child who aged out of a foster placement that's in Florida.
Didn't Michael, the oldest boy, didn't he say that he considered himself a New Jersey resident?
Well, that would be legal determination. Legal residence is legal determination.
But didn't he say that
he did say that, but that's not competent evidence where he's not a lawyer, and there's clearly that's a legal issue. So he did. I mean, again, the hearing officer weighed his testimony, weighed the fact that he got his driver's license, and they were placed in New Jersey when they were 15 and 14 years old, so they couldn't have gotten a Florida driver's license. And they didn't. This is different from a case where.
But as I recall the record, the youngest, I think it's the youngest boy, he got his driver's license almost a year after he turned, or several months after he turned 18.
They got them when they turned 18.
He was emancipated at the point that he got his driver's license.
He was, but they're still living in their Florida placement. They haven't really taken steps to become independent.
He was paying rent.
He was paying rent. He was paying rent.
The stipend that the aunt was receiving had terminated, and once it was terminated, he began paying rent. Subsequently, he obtained a New Jersey license, again, after he was emancipated.
Your Honor, I would argue that all of those are necessary to consider in the totality of the circumstances, but when you have explicit testimony and a year-long manifestation of an intent to move back down to Florida, and when you're saying, I'm staying here for purposes of completing my education, and when Florida law clearly says the establishment of temporary residence for purposes of completing education isn't a permanent legal residence.
But wasn't the testimony that for Joseph that he intended to remain in New Jersey until he could raise enough money to move somewhere down south? I mean, that seems to be very indefinite in terms of how long he was going to stay in New Jersey and when he was eventually going to be able to leave New Jersey.
Right. That was written testimony, so he had a little line in his RTI application about this big where he could fill out that. That testimony was expanded on a year later at the fair hearing where he said, Florida is my home. Florida is the only home I ever knew. That's where I grew up. That's where I was born. That's where my sister lives. That's where I want to move. And so when you have this explicit and you know, he's maintained that intent for at least a year that we've seen from the record and perhaps longer, and he says, I want to complete my education. This placement is helping me, is providing me with the stability to complete my education. That's the best thing for me. And the RTI statute explicitly says foster care children should be allowed to stay with their placement with their foster parents, because that does help them to maintain that stability and get that education. And they were eligible at the age of 18. They are Florida residents at least until they were 18. So at 18, they were eligible because the RTI eligibility looks to the prior year. And so from the point they were 17 to the point that they were 18, they were Florida residents. So what would happen here is, under the Department's interpretation that they could just lose their Florida residency by operation of law or by getting a driver's license, what you have is the choice, under the RTI statute, the valid choice of staying within your foster placement for purposes of completing your education serves to divest you of your legal Florida residence and it destroys your RTI eligibility. And I would argue that's an inequitable result, and that's not what was intended by the RTI statute, which the legislature felt so strongly about it that they could that they codified that intent to promote stability. So, Your Honor, where in Joseph's case he maintained a clear intent to establish himself in New Jersey only to complete his education, and where in Michael's case the hearing officer weighed all the facts, the license, the voter registration, and Michael's testimony about the importance of his education, and found as a finding of fact that is supported by competent and substantial evidence that he chose to remain in New Jersey to complete his education, those two manifestations of intent are insufficient to establish a permanent legal resident in New Jersey, and as such the Secretary's final order should be reversed. Thank you.
May it please the Court, I'm Charles Fahlbusch of the Attorney General's Office, representing the Department of Children and Family Services in the Michael Acosta case. I'm here with Marlene Stern, also of the Attorney General, representing the Department in the Joseph Acosta case. I'd like to take 8 minutes for our presentation on Michael and reserve 7 for Ms. Stern. With regard to the Michael Acosta case, the Department established that Michael Acosta is not a Florida resident.
Well, counsel, let's talk about that. As I recall the record, both the boys, under interstate compact, were placed with an aunt when they were minor children. They were clearly residents of the state of Florida when they were placed with the aunt. Would you concede that?
Yes, Your Honor.
And would you concede that under Florida law they're entitled to stay in the foster setting even after they attain the age of 18?
Yes, Your Honor.
Well, would you suggest that there is some sort of public interest served on the 18th birthday for these two young men to be compelled to return potentially homeless to the state of Florida for them to qualify for this Road to Independence grant?
That's not what is required under the statutes, to my understanding, Your Honor. Yes, the statute, the one statute says they may continue to reside with their foster family. The other statute says in order to receive RTI funds, and incidentally not transitional funds or aftercare services, one must be a Florida resident. Now, somebody doesn't automatically move from being an out-of-state resident to a Florida resident because they turn 18, but when there are indicia that they intend to remain, such as there were in this case.
Now, if they were living under a bridge in Miami-Dade somewhere, would they have been characterized as Florida residents and qualify for RTI?
Yes, Your Honor.
They would?
Yes, Your Honor. I believe so.
So you believe that there's a public policy would be better served to have them living under a bridge in Miami-Dade than living with the aunt where they were placed in New Jersey?
Certainly not, Your Honor, nor does the statute require that. It doesn't require people to live under bridges. It doesn't require people to move back from Florida to Florida at all. What it requires is an order to receive RTI educational benefit funds that a person be a Florida resident. That's all. Is there a public policy served by that? Of course there is. These people contribute to the state of Florida because they are Florida residents. They use their education in the state of Florida. There are numerous public policies and reasons why the legislature would determine that these kinds of funds should be received only by Florida residents.
Let me ask you a question, I'm sorry. How might one establish that they're a Florida resident if, in fact, in this case, they take advantage of their statutory right to remain with their foster family in New Jersey? Is it an all or nothing? If they exercise that right, do they automatically forfeit RTI eligibility? Or how would they establish Florida residents?
I'd be loath to say automatically, Your Honor. We could speculate, and of course it's sheer speculation to say, young people who said, after this semester I'm going to spend my summers in Florida, or once I finish education I'm negotiating with a Florida company to go to work for them as an engineer or as a mechanic or as whatever, because my intent is to return, and established a bona fide reason to believe that even though they were residing out of state temporarily, they were Florida residents. Is that possible? Of course it's possible, Your Honor. It's
okay,
just
so
not
the appellants
situation here.
can take advantage of their statutory right to remain in New Jersey, and at the same time, it's your position they could establish Florida residency?
My ears plugged, and I lost a little at the end of that. But my position is that it doesn't happen automatically. Children can age out of state and still maintain their Florida residence if that's what they actually do. If the indicia is that they are bona fide Florida residents. That's not the case here, and it's certainly not the case with Michael, who said he's not a Florida resident, no indication that he ever had any intent to return. New Jersey driver's license, New Jersey voter registration, told New Jersey that he was a New Jersey resident in order to receive a tuition aid grant. Michael clearly was a New Jersey resident. Now, under other circumstances, might people living out of state be deemed to be Florida residents? Of course, Your Honor. And there may be situations in which that would be the just and appropriate thing to do. But our point is that the legislature sets the policy of the state by Florida statutes. And the legislature says, yes, they can continue to live with a foster family out of state, but to receive these kinds of funds. And incidentally, that is not true for transitional funds or aftercare support services, which have no residency requirement. But for RTI funds, there is a residency requirement, and people need to be Florida residents.
That raises a couple of questions in my mind. Number one, are foster children who are placed with in an out-of-state placement, are they not then put at a disadvantage compared to foster children who remain in a placement in Florida when it comes to being eligible for the RTI grant? Are they not at a disadvantage?
It would appear that they are to a disadvantage. Yes, Your Honor.
Is your position that the legislature intended for those youngsters to be at a disadvantage?
I think the legislature gets to weigh whether the policies that they're pursuing by requiring residence are more important than the policies involved in permitting children to continue to live with their foster families out of state. These kinds of decisions are major policy decisions. They are made by the legislature. There is a place, an interpretation for both of these statutes which absolutely harmonizes. Children can continue to live out of state. If they don't intend to return and don't intend to become Florida residents and aren't Florida residents, they would lose RTI funds.
The other question
that's a decision that's made by the legislature, and they did it. It's not made by us in the judicial system.
I understand. The other question I have, which probably your co-counsel can answer, but I did notice, and you did just mention something about transitional services for which there is no residency requirement. Can you just tell us very briefly what that assistance is?
My understanding, and I'm no expert certainly, transitional funds at least are funds designed to help former foster children with like living expenses. They can't make rent for a few months while they're looking for a job. These kinds of more welfare-oriented kinds of benefits than RTI, which is designed to cover both educational and living expenses so that people may attain education.
Okay, thanks.
Estoppel doesn't apply here because there's no promise, there's no detrimental reliance, there's no exceptional circumstances.
Well, the opposing counsel has suggested that the promise was that the benefits were at least temporarily granted in each instance, and that each of those boys relied upon that by taking some affirmative steps to go to school and other things, and that by relying on that they could have, had they not been given those benefits, they could have gotten on a train or a plane or a car and come down to Florida and cranked into the RTI qualification criteria.
And they could certainly do that anyway, but all the letter said is you're accepted to RTI, and it's clearly conditional, where it also says your continued eligibility for the Road to Independent Scholarship will be reviewed each year during the 90-day period before your birthday.
But did something change between the first time they qualified and the time that they were subsequently disqualified?
We don't know. The petitioner says not, but we can't tell from the record.
Right. So whatever led them to qualify in the first instance led them to disqualify, apparently, in the second instance, but they relied upon the qualification and didn't get in a car, plane, or train, come down to Florida. Could one argue that? That's what opposing
Yes,
counsel has.
I think I can disagree with that, Your Honor. And the point is, all the letter said is you're accepted right now. It didn't say we'll pay you this forever. It didn't say we won't review your eligibility. As a matter of fact, it said we will review your eligibility. Even if the initial acceptance letter was a mistake, and certainly we don't concede that, although it is somewhat peculiar that the date of the acceptance letter is April 16th and the date of the application for Michael is April 26th, along with many of the documents that we're talking about to establish New Jersey residence. But even if it were a mistake, under Your Honor's interpretation, they'd never be able to correct that mistake, ever. You weren't an out-of-state resident, but now, having said you're accepted, we're stuck with paying it to you forever, even though at the first time we reviewed it for our annual review, we discovered you weren't eligible at all. That can't be considered promissory estoppel of the kind that could bind a state agency, Your Honor. With regard to constitutionality, this certainly is far more analogous to the tuition grant cases than it is to welfare cases. Although it may cover some living expenses, the sole reason is to further an education. It requires full-time attendance. There isn't any question that it is far more analogous to the cases that hold that residence requirements are constitutional for tuition grants than it is to the cases that say durational residence requirements aren't constitutional with regard to welfare benefits. This is not a welfare benefit. The fact is that the evidence established that these petitioners were not Florida residents. The legislature can appropriately do that. There is no conflict, and promissory estoppel would not apply. Therefore, we'd ask that the hearing officer be affirmed. Thank you. I'll leave Ms. Stern for the rest of the time.
May it please the Court, my name is Marlene Stern, appearing on behalf of the Department of Children and Families. I'm representing Joseph Acosta, although the issues are similar in the two cases. In the Joseph Acosta case, there are three main issues to be decided. The first is, did the hearing officer assign the correct burden of proof to the department, and did the department carry its burden of proof? The second is whether Joseph Acosta is entitled to renewal of the RTI scholarship based on promissory estoppel. And the third is whether the residency requirement for the RTI scholarship violates the Equal Protection Clause of the 14th Amendment. With respect to the burden of proof, in this case, the department had to prove that it was justified in terminating Mr. Acosta's RTI scholarship.
I don't mean to interrupt you, but you've got limited time. Focus on the third issue just briefly for a moment, if you would.
The right to travel issue, equal protection. Well, most of the cases cited in the petitioner's or the appellant's brief focus on welfare, care for the elderly, those types of issues. But the cases that focus on scholarships and education clearly have said that the residency requirement is constitutional. And in fact,
Judge Marstiller's question earlier went to the fact that these children were placed by the state of Florida in New Jersey with an aunt, and then subsequently they became disadvantaged comparatively because of the state's action to place them.
Yes, I understand. I think, well, first I would say that the state, for all students, has a one-year residency requirement. If you are moving here from out of state, you can't get in-state tuition. Only
yeah, but the difference here
is
that the Acosta young men were in the custody, generally, of the state of Florida. Mm-hmm. And in that capacity, the state placed them where it felt that they would be best served, which was out of state. Mm-hmm. Because of that decision, they are disadvantaged as compared to foster children or former foster children who remained in Florida. And I think that's really what we're grappling with here.
Right, and I understand that. And The statute, however, is clear that there's a one-year residency requirement, and
Well, they
why
were,
there's
they
a
were
resident-
residents when they were placed, right?
I'm sorry, what?
They were residents of the state of Florida when they were placed in New Jersey.
That's right, and the Florida jurisdiction terminated when they turned 18. I'm not sure that there is a fair answer to this question. It's just that the statute is very clear that there is a one-year residency requirement for the RTI scholarship, not the other services available to youth aging out of foster care. Why that is, the statute doesn't really offer insight into that. But the statute is unambiguous, I would say. And for that reason, I think that the final order should be affirmed. Thank you.
Your Honors, nowhere in the statute does it say that by operation of law, upon turning 18, you change your legal residence if you're living outside of Florida once your residence has been established. We're not here to reweigh the evidence in Michael's case. In Michael's case, the hearing officer weighed the evidence and concluded he stayed in New Jersey to complete his education. That is insufficient under Florida law to establish a permanent legal residence. As for the estoppel argument, Your Honor, the Department made a determination of eligibility that was valid and was supported by existing Florida law based on residency. Nothing in the underlying facts changed in terms of their living situation, their schooling, or their progress. Nothing in the underlying law changed in terms of RTI eligibility or legal residence. Nothing in the underlying, the Department's own policies or procedures changed, and the Department did not find or discover any new information that they had not known when they first made the determination of eligibility. At that, therefore, their change in their legal position as to eligibility was completely arbitrary, where they've made a valid determination of eligibility based on existing Florida law. They should be stopped from taking a contrary position later on arbitrarily without any change in the law or facts that is contrary and detrimental to the very children that the Department exists and has a fiduciary duty to protect, especially when this determination is self-serving and puts the students at a gross disadvantage. And for those reasons, and especially for the reason of legal residence that has not been established in New Jersey, the final order should be reversed. Thank you.
Thank you. Well, we thank you for both sets of attorneys for some very able advocacy this morning. We appreciate that. We appreciate your time and hard work, and we are adjourned.